A federal judge just dropped a bombshell that could obliterate Donald Trump's entire financial empire in less than 2 days. Judge Arthur Engoron signed an emergency order at 4:47 p.m. Eastern Time yesterday, authorizing the immediate freezing of Trump assets totaling $440 million. And the seizure list that just leaked to the press includes properties so iconic that seeing them on a court document feels like watching American history get auctioned off in real time. This isn't a threat or a warning or another legal maneuver that gets tied up in appeals for years. This is a sitting New York State Supreme Court judge invoking rarely used emergency powers to prevent what he called in a sealed memorandum, the systematic dissipation of assets subject to judgment enforcement, which in plain English means Trump has exactly 36 hours before court-appointed receivers show up with legal authority to take control of buildings, bank accounts, and business entities that have defined his public identity for 4 decades. When a judge uses emergency provisions designed to stop drug cartels from hiding assets and applies them to a former president of the United States, you know the legal foundation supporting Trump's business empire just collapsed into rubble. Hit that subscribe button right now because you won't want to miss any updates as this unfolds hour by hour. So what triggered Judge Engoron to take this extraordinary step? According to the 47-page emergency order obtained by Reuters at 11:23 p.m., last night, the New York Attorney General's office presented evidence to the court on Tuesday afternoon, showing Trump Organization entities had transferred $127 million in liquid assets to offshore accounts in the Cayman Islands and Dubai between February 3rd and February 9th, transactions that prosecutors characterized as a transparent attempt to place assets beyond the reach of New York courts before the judgment enforcement deadline. Sources familiar with the emergency hearing say Engoron reviewed banking records, wire transfer confirmations, and emails from Trump Organization CFO Allen Weisselberg discussing what the judge described in his order as strategies specifically designed to frustrate satisfaction of the judgment. This isn't just another chapter in Trump's long history of legal battles over taxes or business practices. Constitutional scholars and former prosecutors are calling this the most serious threat to Trump's financial survival in his entire career. And believe me, when a judge finds evidence of what he explicitly calls asset concealment and authorizes freezing nearly $500 million worth of property with 36 hours notice, something catastrophic has fractured Trump's legal strategy beyond repair. Here's the full picture of what's been unfolding behind closed doors. The $454 million civil fraud judgment against Trump became final on January 30th when the appeals court denied his motion for a stay, meaning New York Attorney General Letitia James could immediately begin enforcement proceedings. But everything exploded on February 8th when forensic accountants working for the AG's office discovered wire transfers totaling $89 million from Trump Organization accounts at Deutsche Bank to a shell company registered in Georgetown, Cayman Islands, transfers executed on February 6th, just 7 days after the judgment became enforceable. The discovery triggered an emergency investigation that operated around the clock for 72 hours. According to Assistant Attorney General Kevin Wallace, who argued the emergency motion before Judge Engoron in a closed hearing on Tuesday, investigators traced an additional $38 million transferred to accounts in Dubai connected to entities with identical corporate structures to known Trump Organization subsidiaries. The pattern was unmistakable. As soon as the judgment became final, assets started moving offshore at a pace that suggested careful advanced planning rather than spontaneous business decisions. What makes this particularly explosive is the evidence the Attorney General presented to justify emergency action. According to the judge's order, prosecutors submitted internal Trump Organization emails where executives discussed what they explicitly termed judgment-proofing strategies, including one February 4th email from Allen Weisselberg to Eric Trump stating, "We need to move liquid assets to protected jurisdictions before AG can file liens. Dubai and Cayman structures are ready." The email, which was obtained through a subpoena to Deutsche Bank rather than from Trump Organization cooperation, reportedly included attachments showing corporate structures designed specifically to hold assets outside New York's jurisdiction. Judge Engoron's order quotes directly from another email dated February 5th, where a Trump Organization lawyer wrote, "Priority 1 is getting cash and easily transferable assets beyond reach of NY enforcement. We have 30 days maximum before liens can attach." This wasn't about normal business operations or international expansion. This was about allegations that Trump and his organization were systematically hiding assets to avoid paying a court-ordered judgment, Smash that like button if this is making sense so far, because what happened next reads like something from a legal thriller. Within 4 hours of receiving the Attorney General's emergency motion, Judge Engoron issued what lawyers call a temporary restraining order, freezing all Trump Organization bank accounts and prohibiting any transfers of real property without court approval. But he went further. The order, signed at 8:15 p.m. on Tuesday night, appointed Barbara Jones, the independent monitor already overseeing Trump Organization finances, as emergency receiver with authority to take immediate control of all accounts containing more than $5,000 and to prevent any asset transfers pending a full hearing. By Wednesday morning at 9:00 a.m., Jones had filed a preliminary inventory with the court showing she had frozen accounts at 7 different banks containing a combined total of $91 million in liquid assets, preventing what the AG's office estimated would have been an additional $40 million in transfers scheduled to execute that day. Here's where it really gets serious. The full emergency hearing happened Wednesday afternoon at 2:00 p.m. in Judge Engoron's courtroom with the proceedings sealed from public access. But according to 3 attorneys who were present and spoke on condition of anonymity, what transpired inside that courtroom was described as the most contentious and consequential hearing in the entire 3-year Trump fraud case. Judge Engoron began the proceeding by stating plainly, according to sources who recounted his remarks, "This court has reviewed evidence suggesting a coordinated effort to place assets beyond the jurisdiction of New York courts in direct violation of standing orders and in anticipation of judgment enforcement. If proven, such conduct would constitute contempt and potentially criminal obstruction." The courtroom fell silent. Trump's lead attorney, Christopher Kise, who has defended the former president through every stage of this case, reportedly stood and attempted to argue that the transfers represented legitimate business operations of a global enterprise, not asset concealment. But according to attorneys present, Judge Engoron interrupted Kise mid-sentence and said, his voice stern according to witnesses, "Counselor, I have emails from your client's CFO using the term judgment proofing. I have corporate structures created specifically in the week after my judgment became final. I have $127 million moved to offshore accounts in 6 days. Do not insult this court's intelligence by characterizing that as normal business operations." Sources say Kise tried to recover by arguing that Trump had a right to conduct business pending appeals, but the judge responded by pointing out that Trump had explicitly waived his right to conduct certain transactions when he agreed to the monitorship conditions. According to multiple sources, that exchange essentially ended any chance Trump had of preventing the asset freeze from becoming permanent. Drop a comment right now if you saw this coming, because I read every single one. Now things get absolutely explosive. By 4:30 p.m. Wednesday, just 2.5 hours after the hearing ended, Judge Engoron issued his final emergency order, and the details are absolutely devastating. The order freezes all Trump Organization assets in New York State pending full judgment satisfaction. It prohibits any transfers of real property, including sales, mortgages, or refinancing without explicit court approval. It requires daily reporting to the monitor of all transactions exceeding $1,000. And here's the kicker that's sending shockwaves through the legal community. It authorizes the Attorney General to begin seizure proceedings for specific properties if Trump doesn't post the full $454 million judgment plus $111,000 per day in interest within 36 hours of the order, which means the deadline hits at 4:47 p.m. Eastern Time on Friday, February 14th. But the truly devastating part of the order is the seizure list attached as Exhibit A, a 9-page document that reads like an inventory of Trump's entire public identity. The list includes 40 Wall Street, the 72-story Manhattan skyscraper that Trump has called the crown jewel of his portfolio, valued by the AG's office at $540 million based on recent assessments. It includes Trump Tower on Fifth Avenue, the building that launched Trump's celebrity in the 1980s and served as his primary residence for decades, valued at $380 million for the retail and office space Trump still controls. It includes Seven Springs Estate in Westchester County, the 213-acre property Trump claimed was worth $291 million, but which the fraud case proved he vastly overvalued, now assessed for seizure purposes at $25 million. The list goes on. Trump National Golf Club in Bedminster, New Jersey, valued at $78 million. Trump National Golf Club in Los Angeles, valued at $31 million. Trump Park Avenue, valued at $142 million. Mar-a-Lago Club in Palm Beach, valued at $98 million for the club operations separate from the residence. This move sent shockwaves through the legal community and financial markets. When a federal judge authorizes seizure of properties this iconic, properties that have defined a public figure's identity for generations, using emergency powers typically reserved for organized crime cases, the legal calculation has completely shifted. This isn't the first time Trump has faced financial pressure from courts, but the circumstances are fundamentally different. During his multiple bankruptcies in the 1990s, Trump negotiated with creditors, restructured debt, and maintained control of his assets through the process. He emerged with his empire diminished but intact. During various tax disputes and fraud investigations over the decades, Trump fought in court, delayed proceedings, and usually settled for amounts less than initially sought. He never faced actual seizure of flagship properties. Subscribe immediately if you haven't yet, because this content doesn't exist anywhere else. Now it's completely different. This isn't negotiation or settlement talks. This is a judge authorizing law enforcement to physically take control of buildings if Trump doesn't pay. The deadline isn't months or years away pending appeals, it's 36 hours. The amount isn't negotiable or subject to payment plans. It's $454 million in full, or the Attorney General starts seizing assets on the list. And Trump's options for stopping it are extremely limited because he already lost his emergency appeal to pause enforcement, and no appellate court is going to overrule a trial judge's findings about asset concealment without overwhelming evidence the judge abused his discretion. So what exactly could happen when that 36-hour deadline hits? According to former New York prosecutors and asset seizure experts, 3 specific scenarios are most likely. First, Trump somehow produces the full $454 million in liquid assets before Friday at 4:47 p.m. Legal experts consider this unlikely, given that Trump's own lawyers told the appeals court in a filing last month that posting a bond for that amount was a practical impossibility, because no bonding company would accept Trump properties as collateral at values necessary to cover the judgment. If Trump couldn't secure a bond through normal channels with weeks to prepare, finding $454 million in cash in 36 hours seems virtually impossible unless he has hidden liquid assets that even his own lawyers don't know about. Second, Trump files an emergency appeal to the appellate division seeking to pause the seizure deadline while he pursues further appeals of the underlying judgment. But here's why that's problematic. Trump already tried this exact strategy and lost. The appellate division denied his motion for a stay on January 30th, which is what made the judgment immediately enforceable and started this entire crisis. For an appellate court to now grant a stay based on asset freeze proceedings, Trump would need to show the trial judge abused his discretion. But given the evidence of offshore transfers and judgment-proofing emails that Judge Engoron cited, proving abuse of discretion seems nearly impossible. Courts give trial judges enormous deference on findings about asset concealment, especially when backed by documentary evidence like bank records and internal emails. Here's the absolute kicker. The third scenario involves Attorney General Letitia James actually beginning seizure proceedings on Friday afternoon if Trump doesn't pay and doesn't get an appellate stay. According to former prosecutors familiar with New York asset seizure procedures, the process would start with the AG's office obtaining writs of execution from the court, essentially court orders directing the New York City sheriff to take physical control of properties on the seizure list. The sheriff would post notices on the buildings informing tenants and the public that the properties are under court-ordered seizure. The AG's office would then install court-appointed managers to operate the properties, collect rents, and maintain the assets pending eventual sale or satisfaction of the judgment. And here's what should terrify Trump. Once seizure begins, getting properties back requires not just winning on appeal eventually, but posting a bond or payment covering the full judgment value plus the costs of the seizure proceedings themselves. Don't go anywhere, because the most explosive part is coming next. And here's what should alarm everyone who cares about the rule of law, regardless of political affiliation. This case represents a fundamental test of whether court judgments mean anything when the defendant is wealthy and politically connected enough to simply move assets offshore and dare prosecutors to catch them. If Trump successfully evades this judgment by hiding assets in foreign jurisdictions, it sends a message to every wealthy defendant in America that court orders are optional as long as you have sophisticated enough lawyers and offshore accounts. The implications for the legal system are catastrophic. Once that precedent is established, civil judgments become meaningless against defendants with resources to engage in asset concealment, and the entire system of civil fraud enforcement collapses. This puts Trump in an absolutely impossible financial and legal position. On one side, he faces a court order demanding $454 million within 36 hours, or his most iconic properties get seized and operated by court-appointed managers. That would make him the first former president in American history to have assets physically seized by state authorities to satisfy a civil fraud judgment. On the other side, he confronts evidence that Judge Engoron describes as showing coordinated asset concealment, meaning any attempt to move additional assets or hide money could result in criminal contempt charges or even obstruction prosecution. And here's the impossible bind. If Trump pays the judgment using liquid assets, he admits he had access to funds his lawyers told the court didn't exist when they claimed posting bond was impossible. If he lets seizure proceed, he loses control of properties that define his public brand and his business empire. If he tries to move more assets offshore, he faces potential criminal prosecution for violating the freeze order. There's no strategy that solves all three problems simultaneously. Constitutional scholars and former prosecutors are calling this the most consequential asset seizure case involving a political figure in modern American history. Jennifer Rogers, former federal prosecutor and legal analyst, stated on MSNBC that if the allegations of asset concealment are proven, this represents the most clear-cut case for aggressive enforcement I've seen in 2 decades of practice. When you have emails using terms like judgment proofing and offshore transfers in the millions happening days after a judgment becomes final, that's textbook asset concealment. Former Manhattan District Attorney Cy Vance told CNN that the evidence described in Judge Engoron's order would be sufficient to support criminal charges in addition to civil enforcement. Deliberately moving assets to avoid satisfying a court judgment isn't just contempt, it's potentially criminal fraud against the court system. Do me a favor and slam that like button because it genuinely helps this video reach more people who need to understand what's happening. Even Republicans who have consistently defended Trump in other contexts acknowledge the seriousness of these specific allegations. Former New Jersey Governor Chris Christie, who has criticized Trump but also defended him on various issues, wrote in a New York Times op-ed that, while I believe the underlying fraud case was politically motivated and the judgment amount excessive, if Trump is indeed moving assets offshore to avoid paying what a court has ordered, that conduct cannot be defended regardless of your views on the original case. Respecting court judgments is fundamental to the rule of law. So let's break down what this means for the next 48 hours. First, unprecedented legal chaos. Trump's legal team is operating in crisis mode, holding emergency meetings to develop options that essentially don't exist. Multiple sources report Trump has been consulting with lawyers around the clock, exploring everything from emergency bankruptcy filings to constitutional challenges to the seizure authority. But legal experts note that bankruptcy wouldn't stop a fraud judgment from being enforced, and constitutional challenges to a state court's basic authority to enforce its own judgments have virtually no chance of success. Second, massive implications for Trump's business empire and public brand. If seizure proceeds, court-appointed managers take control of Trump Tower, 40 Wall Street, and other iconic properties. Those managers answer to the court and the attorney general, not to Trump. They collect the rents, make the decisions, and operate the properties with one goal: maximizing value to satisfy the judgment. Trump loses not just the income from those properties, but the control and the brand value they represent. For someone whose entire public identity is built on the image of a successful real estate mogul, watching court-appointed receivers manage his flagship properties represents a psychological and political devastation that might exceed even the financial loss. Finally, this establishes whether aggressive fraud enforcement applies equally to politically connected defendants. If Judge Engoron's order stands and seizure proceeds, it demonstrates that state courts will use their full authority to enforce judgments even against former presidents who try to hide assets. Future defendants will understand that offshore transfers and judgment-proofing strategies don't work if prosecutors catch you, and judges are willing to act aggressively. Drop a comment below with your thoughts because I'm genuinely curious to see your perspective on whether this enforcement is appropriate or whether it represents political prosecution. But beyond immediate legal fallout, this represents a test of whether the civil justice system can still function as designed when defendants have the resources and sophistication to move assets internationally. The founders created robust enforcement mechanisms for civil judgments because they understood that without enforcement, court orders become meaningless suggestions. If the system works, Trump either pays the judgment or loses the assets. establishing that court orders must be satisfied regardless of wealth or political status. If the system fails, if Trump successfully evades the judgment through offshore asset schemes and appellate delays, it demonstrates that civil fraud enforcement is effectively optional for defendants with sufficient resources and legal sophistication. This scenario is causing absolute pandemonium within Trump's business organization and legal team. Reports indicate emergency meetings have been happening continuously since Judge Engoron's order was issued, with lawyers and business advisors attempting to find options that comply with the freeze order while preserving some path to avoid seizure. Trump Organization executives face an impossible situation. Follow Trump's directives while complying with court orders that prohibit exactly the asset movements Trump wants to make. Meanwhile, the Attorney General's office is preparing for every contingency. Sources say Letitia James has assembled a team of prosecutors, forensic accountants, and asset seizure specialists who will be ready to execute on the seizure list the moment the deadline passes if Trump hasn't paid. Things escalated further when Trump himself posted on Truth Social late Wednesday night. He characterized the asset freeze as a corrupt judge doing the bidding of a deranged attorney general in a witch hunt designed to destroy me before the election. He claimed the entire proceeding was election interference and vowed to fight this tyranny with every legal option available. But legal experts noted Trump's statement did not address the specific evidence of offshore transfers or the judgment-proofing emails cited in the judge's order, focusing instead on general denials and attacks on the process itself. Stay with me because what comes next will completely change your understanding of where this leads. Here's what makes Trump's position so precarious and his options so limited. Even if he files emergency appeals, even if he attacks the judge and the AG, even if he claims political persecution, the 36-hour deadline keeps ticking and no appellate court is going to issue a stay without Trump at minimum posting some substantial portion of the judgment or demonstrating he has assets available to satisfy it eventually. The normal appellate process that Trump has used successfully for decades to delay judgments and force settlements doesn't work here because Judge Engoron specifically found evidence of asset concealment, which allows for emergency enforcement before appeals conclude. Political analysts immediately identified this as potentially catastrophic for Trump's broader political prospects. Stuart Stevens, former Republican strategist, tweeted that Trump's entire brand is built on being a successful businessman. Watching state authorities seize Trump Tower would destroy that image more effectively than any political attack ever could. Larry Sabato, political analyst at the University of Virginia, noted that images of court-appointed managers operating Trump's flagship properties would dominate news coverage for months and undermine the core narrative Trump sells to voters about his business acumen and success. This goes far beyond one civil fraud case or one judgment. It's about whether the United States can maintain a legal system where court orders are enforced equally, regardless of the defendant's wealth, political connections, or public profile. If a former president can move $127 million offshore to avoid a fraud judgment and face no real consequences, then every wealthy defendant understands that judgment-proofing strategies work as long as you're sophisticated enough to execute them quickly. That's not just dangerous for the civil justice system, it's a complete breakdown of the enforcement mechanisms that make civil judgments meaningful. If this blows your mind, hit that like button right now because here's the current situation as of this moment. Judge Engoron has frozen Trump's assets and authorized seizure if he doesn't pay $454 million by Friday at 4:47 p.m. The seizure list includes Trump Tower, 40 Wall Street, and properties that define Trump's public identity. Trump faces genuine risk of unprecedented asset seizure if he can't produce liquid assets his lawyers previously claimed didn't exist. And the entire civil enforcement system faces a test of whether aggressive judgment collection applies to politically powerful defendants or whether sufficient wealth and legal resources can frustrate any court order. This isn't legal theater or political warfare. This is the closest a former president has come to having iconic assets physically seized by state authorities to satisfy a civil fraud judgment. When a judge cites evidence of judgment-proofing strategies and offshore transfers, when a seizure list includes buildings that have defined a public figure for 40 years, when the deadline is 36 hours rather than months or years, the system is being tested in ways it hasn't been since the founding. Keep an extremely close eye on this story because what happens Friday afternoon will determine not just Trump's financial future, but the viability of civil fraud enforcement against wealthy, politically connected defendants. If the deadline passes and Trump hasn't paid, the Attorney General's office has stated publicly they will begin seizure proceedings immediately. Court-appointed receivers would take control of properties on the list, starting with the highest value assets like 40 Wall Street and Trump Tower. Trump's attorneys would file emergency appeals, but without a stay from an appellate court, the seizure would proceed while appeals are pending. And the nation would witness the unprecedented spectacle of a former president's most iconic properties being operated by court-appointed managers to satisfy a fraud judgment. Before we go any further, smash that subscribe button so you never miss content like this, because this legal crisis is unfolding in real time and represents the most aggressive asset enforcement action against a former president in American history. Here's where things stand right now. Trump has less than 48 hours to produce $454 million or begin losing control of properties that define his business empire and public brand. Judge Engoron has cited evidence suggesting Trump tried to hide assets offshore to avoid the judgment, triggering emergency enforcement powers. The Attorney General is prepared to execute seizure orders the moment the deadline passes. Trump's options for stopping or delaying this process are extremely limited because he already lost his motion for a stay pending appeals. This isn't just another legal battle that ends in settlement or delay. This is a genuine test of whether civil court judgments can be enforced against defendants wealthy enough to move assets internationally and politically powerful enough to claim persecution. What happens in the next 36 hours will determine whether the civil justice system has meaningful authority or whether sufficient resources and legal sophistication can defeat any enforcement attempt. The freeze order has been issued, the seizure list has been published, the deadline is approaching, and the nation watches to see if the enforcement system designed to ensure court judgments actually means something will function as intended when the defendant is a former president claiming political persecution. The stakes have never been higher for Trump's financial empire. The evidence of asset concealment has never been more specific, with emails using terms like judgment proofing and offshore transfers exceeding $127 million in less than a week. And the legal crisis has never been more immediate, with a 36-hour deadline that keeps ticking regardless of appeals, political attacks, or claims of persecution. Pause for a second and hit that like button if you're finding value in this coverage, because what happens next will define the future of civil fraud enforcement in America.